What you know, alibis? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. It's good to have you here. It's Friday. I'm doing a little catch up. I was at Disney all week, had a blast with my youngest, Fruit Loop and Brienne from the hiding place, and her kids came. Can't tell you guys how much fun I had. Also, can't tell you how sore my entire body is, but it was worth it. We're going to jump in. But first, you know the drill. If you're watching on YouTube, subscribe, like, and share the video. Hit that little bell if you want notifications of when I post new content. Music fact of the day is actually just going to be a little homework assignment because Charlie Adelson's back in Florida. That's right. I got a notification on my phone. He's back. If you're on YouTube, you can see his new mugshot looking more like the old Charlie with the curly hair back in play, not slicked back like that last mugshot we got. So, the music fact of the day that just popped in my head when I heard this, go listen to Mama, I'm Coming Home by Ozzy Osbourne. Just made me think of Charlie. All right. So they gave a little roadmap that they put out during the hearing as far as how long this trial is going to last. Prosecutor Kappelman predicts 6 to 7 days for their case, and they do the math. So if they have a jury, the first day of testimony would be next Friday, September the 20th, meaning the state could possibly rest that following Friday, September the 27th, and the defense case would begin around Monday, September 30th. The defense says they do have a bit of a time pressure because of the Jewish holidays. I am going to try to get down there maybe a week from Monday. We'll see. It's very fluid right now, but I would like to make it down there. Also, one thing I have been doing is I have found a really easy way for me after all this time to clean up the audio on the wiretaps. I've uploaded several today. A lot of people have commented it's much easier to listen to. I may do those with the jail calls as well. It really enhances the audio, drowns out some of that background noise. We'll see, but I'm going to continue uploading these wiretaps this weekend because I still have several to go that I haven't put up after all this time. But let's jump into this final pretrial hearing before she goes to trial. On the motion to quash the defense subpoena, the defense's position is that they don't seek to elicit testimony from Charlie's former attorney, David Marcus. Now, he was present yesterday, by the way, for this hearing. The state intends to ask Charlie's former attorney about three things that point to the conspiracy. The first, the state has indicated they intend to ask Detective Isom if Mr. Marcus called immediately after Katie was arrested to see if Charlie was also going to be arrested. The defense says if that's just left there, the jury takes away the defendants were all in cahoots. And the defense believes Mr. Marcus will testify that's not the case at all. And he would tell how he received information about Katie's arrest and how he knew to call investigator Isom. The judge asked Mr. Marcus, Charlie hasn't waived any privilege with you, has he? And Mr. Marcus says that's correct. Mr. Marcus says that the call to Detective Isom, he doesn't understand how the state putting this into evidence is relevant, and his response should be suppressed. He said when he learned the morning that Katie had been arrested, he called the detective to find out if Charlie was also going to be arrested. There's nothing wrong with that. Any good lawyer would do it. He said, I inquired about Charlie. It had nothing to do with Donna Adelson. And even if this was a trial about Charlie, I still don't think it would be relevant. There's nothing abnormal about me calling the detective to ask about Charlie. He asked the judge that the whole snippet be excluded. The judge asked the state if they intend to elicit information about this. Prosecutor Kappelman says yes, the call to Isom, which goes to their conspiracy theory. Now, Charlie's former attorney, Mr. Marcus, says there's no basis to argue the existence of a conspiracy by him calling the detective to see if Charlie was going to be arrested that morning as well. He tells the judge this is just a conspiracy theory with no basis in fact. The judge says, as a factual issue, did the phone call take place? And there's nothing protected concerning that. How that fits in the larger narrative of what may be admissible or not remains to be seen. But the state can put on their case and ask him and the defense can rebut that. The judge said he would deal with any objections by the defense at that time. The second category is the state has investigated vigorously that the Adelson family had provided legal fees for other lawyers or other co-defendants in the case. But as recently as January, the FBI was down in Miami speaking with Mr. Marcus about those things, but nothing ever came to fruition, and there were no discussions with any co-defendants or any of the Adelsons. Now, Mr. Marcus said that he addressed the legal fees in his motion, and he doesn't think the state will elicit anything about that. He says the state has released him from his subpoena about this issue, but he isn't sure if the defense needs him to rebut anything about this. For the legal fees of Katie being paid by the Adelsons, the state says, yeah, this also goes to the conspiracy. Now, the defense says Mr. Marcus did something that's common for him and other attorneys to do. He didn't confer with his client, Charlie, but he did reach out to Katie's attorney about sharing expenses. It was Mr. Marcus's suggestion, not the Adelsons, for any offer to pay fees. The state can inquire about that, by the way. The judge says if any objection needs to be raised, the defense can do so at that time. The third category, Mr. Marcus told Charlie about him, meaning Mr. Marcus, having seen or bumped into Katie outside of his office. In return, Charlie texted Donna about this. The state wants that text to come in. Now, this was not made clear at the beginning of the hearing. The defense made it sound as if the text was between Charlie and Mr. Marcus. It was later cleared up by the defense that the text was between Charlie and Donna. The state said this text was found during the search warrants on the phones. The judge says if it doesn't include any advice he's giving Charlie, it can be brought in because it's a communication between co-conspirators. Objections can be raised during the trial, and Mr. Marcus will be called as soon as the state rests. And Mr. Marcus tells the judge he thinks that this will be debated later because he doesn't see how it's relevant. The next issue, the summary with Sgt Corbitt. The defense talks about an email between Donna and someone named Renee Griggs, who is Donna's or was Donna's life coach. The defense says this email is hearsay. The state said they're offering it because Donna explains she's stressed about Wendy not being able to relocate. Wendy doesn't realize how much it'll affect the whole family if it doesn't happen. And the comments from the counselor's concerns about Donna's stress level adds context, and that's why they want to bring it in. The judge will allow that in. The defense says the problem isn't Donna's comments, it's Renee's email to Donna being hearsay. And the defense reads what Donna said in the email. She says, I'm stressed about my son, but honestly, I'm more stressed about Wendy and what would happen if she doesn't get relocation at the June hearing. Her life will change drastically if she has to remain in Tallahassee, and so will ours, and not in a good way. But I'll tell you more about it when we talk. Donna ends the email by giving good wishes to the woman's mother, who apparently is sick. Now, the defense says they have no objection to Donna's part coming in. He reads Miss Griggs' response about her mother being sick, says it seems Donna has a great deal of weight on her shoulders. I could both hear and feel it in our phone conversation the other day, and I would like to help you shed whatever feels so heavy. So please know I'm thinking of you and looking forward to our work together whenever you're ready. Now, the defense again says that Miss Griggs' response isn't relevant. The judge asked Prosecutor Dugan what the context is, and the prosecutor says that in Miss Griggs' response email, it gives Donna's comments context. The judge reserves ruling on that one, so I'll keep an eye out. The next issue, Sgt Corbitt is estimating how long travel takes, and they want it removed because they say it's speculation. The judge asked the state if Sgt Corbitt did calculations that can be demonstrated as reliable, and the state says yes, they have actual versus optimal travel by Wendy on the day of the crime. There are cell tower records that show as she leaves her house and then goes by the crime scene, then to an ABC liquor store, and then out to lunch. They also have other evidence, like the receipt from the ABC liquor store she had that day. On the visual, there is a red dotted line which represents the shortest route she could have taken to get from point A to point B, her home to another liquor store and then to the restaurant. He uses a mapping company called ESRI, which the state says the Florida DOT uses for their calculations. Sergeant Corbitt uses it regularly, knows it's reliable, and he's tested it himself. What this will show is the mileage and how long it should have taken with the more direct route, which would have taken half the time compared to the route Wendy took. Now, we know she drove by Trescott Drive after the shooting. The defense actually says they'll withdraw their objection to this. So, the next issue on August 2nd, 2016, this is after Sigfredo and Rivera had been arrested. There are some text messages between Charlie and Donna. Charlie's messages, according to the defense, are hearsay and they're not in the furtherance of a conspiracy. The state disagrees and says they're co conspirator statements. So, from Charlie to Donna, did you see in the paper where the state's star witness that rented the hotel room is a convicted cocaine dealer? Maybe those guys were just up in Tallahassee buying drugs and just in the wrong place at the wrong time. Maybe the coke dealer did it because Danny didn't pay for his drugs, just like he stiffed everybody else he did business with. The whole thing is just crazy. Donna says, I didn't see which paper. Charlie says, the Tallahassee Democrat. Donna responds, wow, I've stopped reading everything. Charlie says the guy admitted to selling them cocaine and hanging out with them. Donna says, OMG, with an exclamation point. Prosecutor Dugan says this is co conspirators celebrating another possible explanation that does not involve them for Dan's murder. The defense says he just doesn't understand the point. He said he can bring in the entire text thread to show the judge that's not what's happening here. The judge said he will review it, but he says the problem with this is the communication doesn't have to be so overt as to them saying this is where the gun is hidden, but them essentially mocking the drug dealer or someone else that has been arrested in furtherance of their conspiracy. He asked the state to explain that a little more. The state says, well, they also said they were being extorted. And at the time this text was sent, Sigfredo and Rivera both had been arrested, and Charlie and Donna would have known the men behind Dan's murder have been arrested. And if they've been extorted by them for several years, why are they theorizing another possible explanation for the murder? That he was killed by a cocaine dealer for stiffing him. Why are they celebrating and theorizing something that doesn't involve them? The judge says he follows her logic, and this is being brought in to rebut an extortion defense. The defense says you have to look at what Donna says. She says she doesn't know what he's talking about, and Donna doesn't respond in any way to what he's saying. The judge reserves his ruling. He says if it comes down that Donna was relying on Charlie's statements in some way concerning her behaviors and how she conducted herself about the extortion, and if the state plans to rebut the extortion theory, it is permissible as to that basis, but not as to the truth of the matter. If it's brought in, a limiting instruction may be given. The next issue, text between Donna and Wendy after Charlie's conviction. The texts by Donna are fair game, according to the defense, but the texts by Wendy are hearsay. And the timing on this is critical because it's hours after Charlie was found guilty. And he says he's not sure how this is in furtherance of a conspiracy. The state said there are several messages between them, and she would only be using from when Donna says, I guess she puts an emoji with prayer hands, we shouldn't have to pray. He's telling the truth, protecting his little sister from years. And then she says to the text, your brother protected you for years. Now you're not guilty. The state says they won't offer anything after that. The only thing Wendy says is, I love you. Call me if you can. The defense says if that's all, then we're okay with that. The next objection by the defense, the state says they actually can agree on that. They won't use it in the presentation. So the defense says we're on a roll. And the judge jokes, "Do you need me any further? Can we call it a day?" But that wasn't to be the case because the next issue, the state will be using the Cellbrite extraction for the non extradition countries, but not the emotion. The defense says they're good with that. So Sergeant Corbitt takes the stand, and the state starts questioning him about this summary he is introducing. In these summaries are call detail record summaries, plotting of locations, the routes taken by various people, emails, and text messages. For the summaries, they got phone records for everybody: Wendy, Charlie, Donna, Harvey, Sigfredo, Katie, and Rivera. And there are thousands of pages, as you could imagine. Just one set for Charlie is 4,400 PDF pages and total 190,000 records. If you put it to PDF pages, maybe 8,000, and that's on the lower side. The summary he prepared, he was able to narrow the parties' events as to what law enforcement saw as significant dates for the planning and execution of the murder. There's call summaries between the parties, and the prosecution publishes an example of how this is going to look. Sergeant Corbitt explains what they're looking at there in court. It's not what it looks like when he gets the raw files from the phone companies. So he assembles them by name and subscribers to the numbers to identify who's speaking to who. And he talks about removing duplicates. For instance, if two parties are talking, it'll be on each of their records. And it makes it easier to read who is who, which is which. And that's what they have in this exhibit. There are photos with arrows showing who communicated with who, the time that happened, the amount of time spent on a call. And all of this is based on the data. Some of the records may have iCloud returns, but mainly this is from the call details summaries. But you could have emails between the parties in there. They spend some time going through how this works. For some of the location events, he was able to determine location data for some of these events. He explains the location is from the cell sites the phone is communicating with. So they plot that on a map and start to make determinations about location. A sector or a side of that cell site can help narrow down the location of where that handset was. He uses other things to help him determine location of a cell phone, such as text messages between parties. For example, if Charlie and Katie are planning to meet up, he looks at the call record as well as those location datas to help him confirm he's on the right track. Or if someone texts outside your house, like Donna did to Charlie, does that help you determine based on cell detail records if someone is outside their house? Yes. Other things such as traffic tickets, GPS pings of rental cars, bank records such as Rivera at an ATM, they're all ways that help him nail down where somebody was at a given time and date. He gives an example of how he used the rental car to determine where Katie and Sigfredo were. He knew Sigfredo and Katie drove to the rental car place. And so when Katie dropped Sigfredo off, she calls Charlie because she's alone at that point and she's free to communicate. All that goes into the analysis. In emails, there were statements by Donna provided by Google. The emails were included in the presentation for potential motive for events that were occurring at certain times in the case, such as that custody battle, the emails we went over last week. He said there were a lot of emails, about 87,000 emails from Wendy's account, 57,000 from Donna's. In the end, may use 5 or 6 of those in their presentation. Text messages in the presentation from Charlie's iCloud or cell phone involved Donna's interest in Wendy's custody battle, as well as venting to Charlie about that. In some, there's pushback about the extortion defense. The total amount of text message from all parties was huge. Ballpark for Donna, over 10,000. WhatsApp, and then 20,000 text messages. Charlie's iCloud is over 280,000 messages and between 10 to 20,000 text messages. There were hundreds of thousands of messages between the parties that they had to weed through, but they've included maybe less than 20 chats and 50 or less actual messages. He hasn't counted, but that was his estimate. Now, the defense gets up. There are thousands and thousands of pages, but on the days you're using, if you look at the call summary, it's less than 5 pages. He says it's putting in who's in that summary for that day. The defense says the actual number of pages of emails that will go back to the jury is 6. Those aren't summaries. It's taking pieces of evidence that will already be in evidence and sticking it into a PowerPoint, which is a way of persuading. Within the location data centering on Donna, you're taking her call record and seeing when there's an event, you're looking at the location, and then you're going to a map given to you by AT&T, then looking at the longitude and latitude and plugging it onto that map. He says as part of what he does, he combines Harvey and Donna's records, and there's 3 data sets he uses. There's voice, there's data sessions, and there's text messages. So he isolates those, and then he has to look for valid record locations. From there, each location has to be verified by a database or a location key and then plotted onto a map. And then that gives an estimate of where the phone was based on that information. The witness says with these records at that time, not all locations are accurate. He has to go in and be sure they're usable locations. The defense says on that paper, you can see those times on Harvey or Donna's chart through caller texts. Then you look at the time, which is 8:15, and it gives you a longitude and latitude for each. Then you take an AT&T map and plug that in with the longitude and latitude. The witness says not the AT&T map. They use their own software to do that. The defense continues and says it puts a dot on the map, and it's as simple as looking at the data, plugging it in, and dotting it. The witness says if you took Donna's record and plotted it during that time frame, it would show some invalid locations. The defense says there's no invalid data sessions on that page. The witness says there are. There are continuous data sessions. For example, with Harvey's phone, it shows the original data session as one place, and that continued with time. So essentially, what he's saying here is he knew Harvey had left from the location where the data session originated, even though it said it continued at that same place. The state says that this line of questioning the defense is trying to inquire into is questioning his level of expertise and says, I believe the court ruled he would be able to testify as an expert as far as locations of cell phones. The judge asked if this is going to be an opinion that he's not permitted to give. The defense says he's trying to show there's no expertise in these particular documents, and the documents the state has chosen is demonstrative. It is not a summary exhibit as required by Florida statute. He says we're not arguing his presentation is not a proper summary, but it's a closing argument that should not be sent back with the jury. The judge says he'll permit it, but let's not have a full cross of the witness that goes beyond the issue. So the defense continues. These emails and text messages you pulled, how were they chosen? Did you choose them? The witness says no, the state attorney's office were the ones that chose them. The state goes through what the presentation will have, and she says it's based on the records. We can't give the jury all the records and say, good luck. So as for the maps, these are summaries from the huge cell phone records, text messages, bank records, car rental agreements. They're all in the summary because they helped Sgt Corbitt form an opinion on who had the handset at the time and where that handset was located. It helps verify all the detail records themselves. As far as the email and texts, they're being testified to by a sergeant who specializes in these records. There's thousands of emails. We found lots that go to motive or to the interest of the custody battle. We will use a handful in the presentation. We are using around 50 text messages out of thousands, which are a summary of evidence from the many records. The defense gets back up. Their summary is a closing argument. It's demonstrative. The exhibits that are going to the jury, it's not a ton of them. We're not suggesting he can't have a demonstrative exhibit, but to have over 300 pages of an exhibit is what other rulings have cautioned against. We're just asking the exhibit not go back to the jury room. The state asked if they can respond quickly, and the judge says, so quickly it tickles my ears, and we move on. They say it's not a closing argument. And the defense, they want to talk again. The defense says, when you take lines on a map, you take a text and you put it next to a house, that's taking data and making an argument. The judge said he's previously ruled Sgt Corbitt can testify for historic communication data. He says in researching, he found a recent case that's relevant to this matter. When a summary is accurate and not misleading, it can be properly admitted during trial and include opinions by the preparer as long as the opinion is based on the underlying evidence and data that's admissible. So, the judge will permit a summary be given to the jury. The summary may have a page for the many records or the state's exhibits Sgt Corbitt used in forming his opinions, his method of analysis, and the conclusions he reaches, or any inferences which may be properly drawn from the evidence. But it cannot include anything that's repetitive as far as exhibits go, specifically emails, text messages, videos, things of that nature. The judge said this will cut down the number of pages that go to the jury, but a summary based on the records, exhibits, and opinions of Sgt Corbitt will be permitted. Any additional objections can be raised at trial. The arrow charts and location maps also will be permitted. Emails, text messages, or videos can be cross-referenced as to what Sgt Corbitt used, but not admitted. The demonstrative can be used. Slide 20 is the only outstanding exhibit is yet to be ruled on. And I'm not sure what slide 20 is. I would have to go back and watch the previous hearing about that. But that's it. So we are there pretty much. So just a reminder, I'm not sure if jury selection will be live streamed. I will put it out on social media and I will do a YouTube short. If so, we'll be live streaming that as soon as the first witness is called, live streaming from start to finish every day. And I will also do a summary recapping that day's testimony in an hour or less for those of you who don't want to watch or can't watch, so you don't miss a minute of what goes down in that courtroom. I'm going to keep putting out these wiretaps periodically over the weekend. I want to get those all out before trial starts. And if jury selection is not live streamed, we will figure out something else to cover those few days. But seems like they feel maybe by Thursday they'll have that jury. At least that's their hope. We'll see how it goes. That's it for this Friday. Hope you guys have a good one. We will see you soon.